So, good morning. I'm hoping everybody can hear us. And welcome to this panel on rethinking the service of documents in cross-border transactions, a panel that will look at several aspects of service, from service provisions in contracts, as in the Rockefeller versus SinoType case, and the issue of party autonomy and sovereignty, and how and where the Hague Service Convention fits into this, with its varied interpretations and practices by the contracting states. I am Louise Ellen Teitz, a professor at Roger Williams Law School, and my co-moderator is Professor Ron Brand at the University of Pittsburgh Law School and director of the Center for International Legal Education. And as members of the board of directors of ABILA, we're delighted you're here for ILW in cyberspace, and we're all hoping next year we'll be in person again at Fordham. We have a great panel of experts to discuss several of the current issues involving service of process. I'm going to introduce our four panelists, then I'll give you a 2-minute introduction to the Hague Service Convention. Ron will give you an introduction to Rockefeller and SinoType as an example of litigation of service convention issues, and that will start our panels. Our first panelist will be Giffany Tangelhan, who will talk about the service convention and arbitration proceedings. Giffany is a multi-jurisdictional lawyer trained in common and civil law traditions and admitted in Texas, New York, and in the Philippines. In the Philippines, she worked as a government investigator and antitrust attorney, litigator, and professor at the Centro Escolar University School of Law, CEU. She is currently based in Washington, D.C., where she works as a legal consultant at the International Finance Corporation, IFC, of the World Bank. She obtained her JD from CEU Law, completed graduate courses in public and private international law at the Hague Academy, and received a Master of Laws degree in international business and economic law from Georgetown. Next, Ted Folkman will talk about states' interest in regulating service within its territory and party efforts to waive service under the Service Convention. Ted Folkman is the founder of Folkman LLC in Boston. He's also a member of the American Law Institute. He practices in the area of business litigation, international judicial assistance, and arbitration. Ted is the author of several books and chapters on service of process, taking of evidence abroad, and similar topics, including the chapter on service in the ABA's treatise on international aspects of U.S. litigation. Many of you probably know him as the person behind Letters Blogatory, all one word that is, an award-winning blog on private international law that Ted started and has been publishing since 2011, even through the pandemic. If you don't know the blog, please be sure and look at it. It's Letters Blogatory. Next is Lemuel Lopez, many time zones away in Australia, who will talk about Asian court decisions on service of process in cases involving exclusive choice of court agreements and decisions on granting leave to allow or disallow service abroad. Lemuel has a PhD with specialization in private international law, comparative law, and civil law and procedure from the University of Melbourne. Since 2017, he has taught various law subjects at the University of Melbourne and at Australian Catholic University, including public and private international law, principles of business law, Australian consumer and competition law, human rights and global justice, and international criminal law. Lemuel has several years of experience in commercial transactions and dispute resolution in both the Philippines and Indonesia, and he also served as a legal consultant to the Philippine government. Lemuel is admitted to practice in Australia and the Philippines. And then Robin Efron will put some of these areas together and talk about cross-border notice and service of process in complex litigation. Robin teaches civil procedure litigation and international business law at Brooklyn Law School. Her articles on procedure in federal courts have appeared in several leading law reviews and been cited by several state and federal courts. She serves also as co-director of the Dennis J. Block Center for the Study of International Business Law at Brooklyn Law School. She's an avid writer, penning op-eds for various publications. Prior to joining Brooklyn's faculty, Robin served as a Bigelow Fellow and lecturer at the University of Chicago Law School, and then as a law clerk to Judge Alvin Hellerstein of the U.S. District Court for the Southern District of New York. Once we've heard all our panelists, we'll turn to Q&A, and we'd ask you to type your questions in the Q&A and not in the chat. So now, the Hague Service Convention in 2 minutes. The Hague Service Convention of 1965, which many of you are familiar with, currently has 79 contracting states. It entered into force in 1969. It happened to be the first convention that the U.S. was active in the Hague Conference, and when it ratified the convention, it was the first multilateral treaty for the U.S. to sign onto with respect to international judicial procedure. And it appears to also be the first commission to have first convention rather, to have special commissions at the Hague Conference. Those were meetings directed not at amendment, but on using the existing machinery more effectively. The last special commission considering the Hague Service Convention was in 2014. The Service Convention seeks to simplify the difficult and time-consuming process of making service in cross-border cases. It establishes a framework that streamlines the channels of transmission, primarily using one channel, that of central authorities in each country. But it allows alternative channels as well, including where states approve service by mail. The Service Convention Chapeau speaks of its goals of making sure the addressee has timely notice and improving mutual judicial assistance by simplifying and expediting procedures. The convention applies, quote, where there is occasion to transmit a judicial or extrajudicial document for service abroad. Those 3 words are critical, for service abroad, because what and when transmission abroad is necessary is left to the law of each contracting state. In the US, this is small s state law. When the convention applies, it is exclusive and it must be applied. For the convention to apply, the address of the person to be served must be known, and the document to be served must relate to a civil or commercial matter. You can find everything else you need on the HCCH Hague Conference website, including the central authorities. I'm going to turn this over to Ron to introduce us to the Rockefeller versus SinoType case.
Thank you, Louise, Ellen, and I want to thank all of our panelists for being here, especially Tiffany for putting the program together. I think we have a rich discussion coming up here. My job, I see as one of the moderators, is to basically get out of the way. But before doing that, I want to kind of set up some context here, because there is a single case that has kind of created a greater focus on the Hague Service Convention more recently, and that is the Rockefeller versus SinoType case. So I'm going to briefly go through the history and development of that case, which brings us to really current times. And I think that the talks that each of the panelists is going to give will in some way relate to this. This is a rich case. As an academic, I think you could easily do an entire semester course based on this case, from drafting choice of form clauses to the litigation process and through arbitration, which is interesting here. It began in 2008 when Rockefeller Technology, a US investment partnership, and Changzhou SinoType Technology, a Chinese company, signed an MOU. That MOU had interesting dispute resolution clauses, and you can think about the quality of the drafting as well as the content of the drafting here. But paragraph 8 provided for arbitration before JAMS in Los Angeles, before a single arbitrator. And it said that in the event of any disputes, there would be submission to arbitration. Now that's interesting and not uncommon, but a little bit different were the two paragraphs that preceded that in the MOU, in paragraphs 6 and 7. So paragraph 6, and this gets us into the service issue. The parties shall provide notice in English via Federal Express or similar courier. And then in paragraph 7, even though there's an arbitration clause, there is consent to jurisdiction in the courts of California, as well as consent to service in accord with the notice provisions of paragraph 6, which explicitly provided for notice via Federal Express or similar courier. But keep in mind that that one says notice. As Louise Ellen noted, the word service is important in the convention, and that is not in the parties' agreement here. So there was a dispute that arose, and 4 years later, in February 2012, Rockefeller filed a demand for arbitration with JAMS. SinoType did not appear, although the facts indicate they did receive the notice of the arbitration. And as a result, in November of 2013, there was a default award issued in the arbitration for over $414 million. Now, it's interesting that that was based on uncontested expert testimony. So one could focus on the importance of showing up and dealing with questions like the amount of damages. But it's a rather large arbitration award. Rockefeller then served SinoType in China by Federal Express for court proceedings in the state of California, requesting an order confirming the arbitration award. Again, SinoType did not appear. It resulted in a default judgment in the trial court, at the California Superior Court, in the amount of the arbitral award plus interest. Now, at this point, it's worth looking at two provisions of the Hague Service Convention. Article 1, that, as Louise Ellen noted, tells us that the convention applies when there is occasion to transmit a judicial or extrajudicial document for service abroad. And notably, Article 10 provides that states that the state of, provided the state of destination does not object, the convention shall not interfere with service by mail. But notably, China has objected, and it is one of the states that says we don't allow service by mail. The case proceeded to California Superior Court. In the Superior Court, when SinoType moved to set aside the judgment about 15 months after the original judgment. And one of the reasons for set aside was that they had not been validly served, and that service should have been under the Hague Convention. The court denied that motion to set aside the confirmation judgment. So what did SinoType do? They appealed to the California Court of Appeals. The California Court of Appeals reversed on the grounds that of a finding that SinoType had not been properly served under the Hague Service Convention. The case then went up to the California Supreme Court, which reversed again, holding that service had been proper and did not violate obligations found in the Hague Service Convention. There was a petition for writ of certiorari to the U.S. Supreme Court to take the matter on. That petition was denied in October of 2020. The matter went back down, and most recently, the California Court of Appeal affirmed the denial of SinoType's motion to set aside the judgment. So in other words, kept the confirmation of the arbitral award in place. And in that said, in part, SinoType asserts that the MOU is not enforceable because its language is vague and the waiver of formal service was not clearly labeled. That was rejected in the California Court of Appeal, and the current status is that the original judgment confirming the arbitration award stands. That is the status of that case, and it sets up, it provides an example of where questions on service of process can arise, and that is where we drop it off to our panelists. So Tiffany, take it away.
Hi, everyone. Good morning from whatever time zone you are joining and from whatever part of the globe. Thank you for joining us today in today's panel. Thank you to ABILA, its committees, our sponsors, and of course, the sponsor of today's panel, the International Arbitration Committee, co-headed by Ms. Florian Lavaux of the Debevoise and Plimpton LLP, and Daniel Reich of Galliard Benefit Michel Baya LLP for the opportunity to be part of this panel. In my presentation, I intend to revisit the Rockefeller case as discussed by Professor Brand, and discuss why I believe the Service Convention should not be strictly interpreted and applied mandatorily to arbitration and arbitration-related proceedings. Although many scholars have written on this matter, there have not been a lot of discussion of the case viewed from the lens of arbitration, and that is what I seek to do today. Time permitting, I will answer questions and explore with you the implication of this into the international legal order. But just to start with, I would like to emphasize that my presentation is not in any way reflective or attributable to the organizations that I'm currently or formerly associated with. Second, as per copyright laws and disclosure guidelines, any reference to the portions of my published paper are solely for academic, non-commercial, and scholarly discourse. And there shall not be any reproduction without prior consent of my prior consent or that of the publisher. If you would like to get a copy of the paper, please do so through the Westlaw UK or by getting a copy of the Civil Justice Quarterly. So today I would like to answer some gaps in question, particularly can parties contract out of or around the convention, the Hague Service Convention, in commercial contracts containing ADR clauses such as arbitration agreements, and more particularly focusing on whether the Hague Service Convention should apply to arbitration and arbitration-related proceedings. And when I say that, I mean confirmation, recognition, and enforcement of awards. I will no longer belabor the case of Rockefeller, as that has already been discussed, but I would just like to highlight the provisions that Professor Brand had set forth before you earlier, and that is now currently flashed before you. So the parties had agreed to serve via courier, and they also agreed to a service of process in accordance with their agreed method. And they also agreed to submit the dispute before JAMS in California, the seat being the state of California. I would just like to highlight the importance of this because this means that the dispute had originally stemmed from an arbitration case. In Rockefeller, the Supreme Court of California disposed of it by rendering a very narrow holding. It gave primacy to the parties' contracted method of notice and service, and the Supreme Court treated the parties' mutual consents in their arbitration agreement as an effective waiver of the rights to formal notice and service, which to the court placed the issue of service outside the technical interpretation of the Hague Service Convention, and therefore it only applied to service of process in the technical sense involving formal delivery of documents. I do not contest the validity or the soundness of this decision. In fact, I do agree with the findings of the court. But beyond the narrow holding, I would like to advocate a more expansive approach to the interpretation of the Hague Service Convention and argue in favor of completely eliminating its scope from its scope under Article 1, arbitration and arbitration-related proceedings, because to my view, this will avoid conflicting state interpretations and by domestic courts of contracting state parties and enhance stability in international business transactions. So why shouldn't the Service Convention strictly apply to arbitration and arbitration-related proceedings? The basis of my argument are as follows. First, it is not in line with the object, the purpose, and the negotiating history of the Service Convention. And it also ignores where the case had started from, and which is that is arbitration. It overlooks the nature of the arbitral process, which is a separate legal order, and it also undermines the enforceability and the finality of awards, which the enforcement of which should be governed by the New York Convention and in other cases by the Panama Convention. It also discounts the conflicting decisions, and if we have time, I will go through them, by domestic courts of the state contracting state parties. Also, it ignores the fact that there is no uniform stand taken by the contracting state parties on this matter. It undermines party autonomy or the individual party's consent, and to my mind, undermines the stability of international commerce. And that's why I'm arguing for a more unified approach. I will no longer discuss the Hague Service Convention, as that has already been discussed by Professor Ellen Tates, but I would just like to highlight some of the aims and goals of the Hague Service Convention, that is to simplify the methods of transmitting documents and to bring timely, actual, and effective notice to the addressee, to facilitate proof of service through the model form. And I would like to highlight that it was never intended to modify the substantive rules of service applicable in state parties. Neither did it set any beginning period for under the national procedural law. It was never intended to provide a hierarchy in channels of transmission, and it was never intended to impose specific means or methods of service. In fact, it was envisioned to promote the then growing field of international commerce. The Hague Service Convention's original intent was to facilitate transnational dealings and to give a means of transmission that would hopefully adapt to fast-changing times, and which is being stifled by the strict application and the mandatory recourse to the main channel under Article 5 of the Service Convention. So in the cases set before you, the Volkswagen case, the historical account of and the negotiations of the drafting of the convention supports the view that it should be left to the requesting state to determine whether the document is to be served abroad. And this has already been decided in the case of Volkswagen. In the 2016 Practical Handbook on the Operation of the Service Convention, it bolsters recourse to the lex fori to determine whether there is an actual occasion to transmit document abroad and whether the Service Convention applies. This means that the convention leaves the interpretation and effectively the implementation of the substantive provisions to the determination of the law of the forum. Thus, characterization of the document, whether judicial or extrajudicial, depends on the law of the requesting state. And therefore, the convention does not apply if the law of the forum determines it to be inapplicable. This view has been echoed by the Rockefeller case. And the Rockefeller had held that if formal service of process is required under the law of the sending forum, international transmission of service of documents must comply with the convention. The preemptive effect of the Hague Convention as to service on foreign nationals is beyond dispute. To the mind of the court, failure to comply with the Hague Service Convention procedure voids the service even though it was made in compliance with California law. And to emphasize, it said that this is true even in cases where the defendant had actual notice of the lawsuit. So what is the problem with this very strict interpretation and approach to interpretation? Well, some legal scholars concede that the convention should automatically apply in all instances regardless of the type of the proceedings, and notwithstanding the kind or source of documents involved, whether judicial or extrajudicial, and whether from judicial authorities or just private parties. I advocate a more discerning approach to interpretation and the determination and application of the convention when it relates to arbitration and arbitration-related proceedings. While I agree as well with the proposed brief that was submitted by Professor Brand and other professors of international litigation in the case, I would like to go one step further and argue that the convention should not be made applicable or should at least be interpreted more liberally to favor the agreement made by parties on any mode of service. I'm arguing for a liberal, unified interpretation and enforcement approach in line with the New York Convention's original intent. In my view, courts ought to uphold such service agreements so long as they relate to arbitration and its related proceedings. Since there is no definitive interpretation on the rule of under Article 1 of the Convention, when it relates to arbitration per se and its related proceedings, parties should be able to come to an agreement on the preferred mode of notice and service, as well as decide whether there shall be an occasion to transmit documents abroad in their contracts. The reason why I say this is that the blanket ruling, as in the case of Rockefeller, ignores the true intent and purpose of the convention, the root of the proceedings, the nature of arbitration, and the fact that there are only specific grounds to set aside or annul an arbitral award under the New York Convention, Article 5. And it also leads to the harsh effect of voiding even valid arbitral awards when a court finds that there is waiver of technical or formal service, as in the case of Altos Hornos, which, if time permitting, we will still discuss. Further, the blanket ruling also ignores the state parties' non-definitive positions, including conflicting national legislation and supportive arbitral rules that favor my view. A number of authorities of state parties and other domestic courts of the Hague Convention, such as Japan, Russia, and even China, have considered whether the convention would apply to arbitration, but have never given any definitive position on the matter. While there are international arbitral rules that followed by states that extend as far as completely waiving the application of the Hague Service Convention, for example, if the arbitration rule 2.1, there are other state parties arbitration rules like that in Lithuania that have interpreted the Hague Service Convention as being available even to arbitration. This causes a lot of confusion and leads to instability in international commerce and questions the bindingness and finality of awards. It also does not help that this issue was sidestepped in the case of Rockefeller. So why is this so important? This is very important because as held in the recent survey in the 2021 International Arbitration Survey by the Queen Mary University and Whiten case, it has revealed that international arbitration is still the preferred method of preferred method of resolving cross-border disputes for 90% of respondents, either on a standalone basis or in conjunction with ADR. There is greater support for arbitration in local courts and judiciary, and therefore there is a need to strengthen this moving forward. Further, the blanket ruling also ignores conflicting decisions and instances questioning the convention's application to arbitration. Just some of these cases include the Thessaloniki case, Federacion, Lombard Knight, and these cases we can discuss if there is still time. So what do I argue should be the approach and the proposed solutions? I argue that there should be a revisiting of the Hague Service Convention, which is quite timely as next year in 2022, there is a scheduled special commission meeting by the Permanent Bureau on this matter. There should be an exclusion of arbitration and arbitration-related proceedings, or at least a liberal interpretation in that favor from the scope of the convention under Article 1. There should be an adoption of a unified pro-party autonomy, pro-enforcement, and more liberal approach to interpretation of the Hague Service Convention when it relates to arbitration and arbitration-related proceedings, and an amendment of national law which should reflect a more unified stance by the contracting state parties, of course, if there is a revisiting of the Hague Service Convention to this effect. And the basis for my arguments for the pro-party autonomy approach and enforcement approach, as well as the liberal interpretation, can be based on just some of these cases, which unfortunately, we do not have time to cover. Finally, arbitral institutions and contracting state parties have provided some support to my view, including the arbitration rules of SIAC, IFTA, among others, the ICDR, and those flashed before you. And there are also conflicting statements or positions by state parties, including of that of China, which may or may not support this view. And with that, I would just like to thank you for your intent participation and for listening to my presentation. And I would be happy, and I'm looking forward to answering any questions now or at the end of the panel.
Thank you. I'm going to move to Ted Folkman now, please.
Thanks, Louise Ellen. Let me just get my screen share going. Okay, hello everybody. Thank you to the American branch for the invitation to do this, and thank you to my fellow panelists. This is, I think, a great discussion. I just want folks to know that I had the pleasure really of doing the unsuccessful cert petition in the Rockefeller case for Changsha SinoType, and so if you would like to see a more formal and drawn out presentation of my views, you can get that petition from the Supreme Court's website. I'd like to talk about the state's interest, the state of destination's interest in methods of service, and what that has to say about the waiver that we've seen in the Rockefeller case, similar waivers. For American lawyers, we tend to think about service as being mostly about notice. If you ask an American lawyer, what is the constitutional rule that has the most to do with service? Of course, the answer is due process. And maybe the best statement of the view that service is essentially about notice comes from the mid-20th century, the Mullane case, which basically sets out the view that if the service is reasonably good enough, then there's no constitutional problem with the method. And in some ways, a lot of the other technicalities of service, who is allowed to serve, what is the form of the writ, all those sort of historical things have dropped away from the way that we think about service. And now we focus mostly on, does the method of service that has been used provide adequate notice? And one of the consequences of this is that for American lawyers, we know that notice can be waived, and so we have a natural tendency to look at service as something that can be waived. And in our own domestic practice, we have pre-suit waivers of notice. So this would be, for example, if you have something like a cognovit promissory note, which is basically a confession of judgment. In many states, that is still okay, and the Supreme Court has said it's constitutional. And we also have post-litigation waivers, which can happen in two ways. One is sort of the way that we see in Rule 4D, which is a sort of a formal request for a waiver, and then the defendant actually formally waives the service. But it can also happen in the context of procedural default. If a defendant just fails to raise a service defense, it's waived. I'm really interested for today's purposes in pre-suit waivers, because the issues that arise in post-suit or post-complaint waivers are a little bit different. You know, issues like procedural default and that sort of thing. I'm really only interested right now in can the parties do what they attempted to do in Rockefeller? Can they say, regardless of the objections of the receiving state, the state of destination, we waive limitations that otherwise would be applicable under the Service Convention? That's our way of thinking about service. That's the American common law way of thinking about service, but it's not the only way of thinking about service. And those of you who are familiar with the civil law tradition know that in many countries, service is thought of much more as about the power of the state than as about notice to the defendant. And in fact, in the civil law tradition, there's an entire branch of the legal profession that has a monopoly on the service of the formal service of documents as a sort of a feature of the state's exercise of judicial sovereignty in its territory. This is not totally foreign to our way of thinking either. And if we go back to a case that you all will remember from the first day of civil procedure, Pennoyer versus Neff, we see that the idea of service as power, at one time held a lot of sway in the United States as well. That case, of course, was the case that held that because the state doesn't have the power to arrest someone outside of its borders, process cannot be served outside of the state's borders. My little NB here, and we don't have time to talk about this, is that I think this is really just not correct legal history. But that idea of power as important to service was a big part of our own way of thinking about it until the mid 20th century. To give you an example from the civil law of the same idea, here's the very well-known provision of the Swiss Penal Code, Article 271, which makes it a crime to serve process other than by way of an authorized official of the Swiss government. That is, I think, a very good view of the sort of the basic civil law view on this. And China, which of course was the state that was involved in the SinoType case, also has a provision in its domestic law making it illegal for anybody to serve process in China other than through the convention or through the Chinese, under Chinese law. We just talk for a minute about service by post in the convention. As you heard from Louise Ellen, the main channel of service under the convention is the central authority mechanism, which is Article 5 of the convention, which is a way of sending the document to the foreign government, which then serves it under its own law. Everybody agrees there's no problems with that from an international law perspective. That's sort of the gold standard in some ways. It's very, very hard to see why that is problematic. But there's also Article 10, which is the convention's list of alternate methods of service. And it's really important to see that these methods of service are permitted by the convention if they are authorized by the law of the forum, number one. And number two, that the state of destination has the power to object to them. And that was not actually a new feature of the Service Convention. If you look back at the original Hague Convention on Civil Procedure in, I think, 1904 or 1908, something like that, and also the 1954 Convention on Civil Procedure, you'll see that they all contained that right to object, or that power to object, and to service by post and other alternate methods of service. I would suggest that the reason that the convention and its predecessors contain this power to object is because in order to have a convention, you needed the agreement of the common law states and the civil law states, and the price of admission, the price that the civil law countries exacted was the right to continue to object to methods of service that they regarded as an infringement on their judicial sovereignty. And as has already been said, China has objected to service under Article 10. My basic, we've already heard that the convention is mandatory or exclusive. I think sometimes people don't really get the implication of that. What it means is that if you want to, if the case is subject to the convention, you must use one of the methods that it authorizes, or at least that it permits. There is no other method that is permissible under the convention, and since the convention is a self-executing treaty, there is no other method that is available under U.S. law. So I think it's a super important point. And when we talk about why, when we talk about sort of what the basic policy problem is with cases like Rockefeller, the basic problem is that the folks who are purporting to make the waiver, they're not waiving a personal right that they have. They're not saying, I'm waiving service. You don't have to notify me of the lawsuit. They're waiving the foreign state's objection to the manner of service. And that's the basic problem, I think. Why do we think it's reasonable? Why should states be allowed to object to methods of service on people in their territory? Well, you might say, well, there is really no good reason. But if we look at the the discussions, the travaux, et cetera, from the inception of the convention, this was a topic that was discussed. The civil law states basically said that we oppose service by post because it's a violation of our sovereignty, period. And there was some pushback to that. What's the problem? China, if you object to service by mail, then just don't enforce the judgment if it ever gets back to China. And in fact, I think that's one of the real curiosities of the Rockefeller case, is that almost certainly the judgment that Rockefeller obtained is unenforceable in China precisely because the service was done by post, which makes you wonder why they proceeded that way rather than, for example, just taking the arbitral award to China and confirming it under the New York Convention. But that's maybe another discussion. In response to that view, what's the problem? You have the response of the Germans, who I think really were the driving force in the negotiations for keeping the power to object. And again, it's just a statement of their view that this is something that is exclusively within the competence of the relevant government officials in Germany or in the state of destination. And that's essentially all that one can say from a common law perspective about the answer. The answer is they think it's a violation of their sovereignty to do it. I'm not going to go through the facts of the Rockefeller case, but what I do want to do, just to sort of to try to make my point maybe in a way more persuasively to you than I was able to do it to the justices, is to just give you a thought experiment. I can't see the audience, so I can't ask you to raise your hands, but I think if I were to say to you, would it be okay if the parties reached an agreement like the one that I've put up here? If the parties said, you know what, we want service to be made, we want, if you're going to make service on us, we want you to send over a U.S. Marshal to China and hand deliver the document to the CEO of the Chinese company. Now, of course, no one would actually make that agreement. It's silly, but let's just think about why it would not be okay. Because I assume, this is at least my intuition, I assume maybe others share it, that would not be okay. Like, we would understand that China might have an objection to that has some validity. Well, why would we think that? If we think that there's something problematic about that? Well, we might say China has objected to service by alternate methods under Article 10. But if we think that, if that's the reason that we think that service by a U.S. Marshal in China is not okay, then the same conclusion should apply to post, because China has also objected to service by post under Article 10. Or maybe we're not focused so much on the technicality of the objection, but we say, this is an infringement of Chinese sovereignty, us sending our government officials over there, and we can see why that would be problematic. But if we then say, well, service by post doesn't raise those issues, then essentially what we're doing is we're substituting our judgment about what does and doesn't infringe on judicial sovereignty for the judgment of the foreign government in question. And I think that's exactly what the convention means not to allow when it allows the state of destination to object to service under Article 10. So my view on this is that if, in fact, we want to respect the views of other countries on what is and is not permissible in their territory, that there really is no difference between saying, we can send Tommy Lee Jones from The Fugitive over to China to serve process, with his big Marshall star and, maybe his 6-shooter. There really is no difference in principle between that and saying we can serve by post, because what makes it wrong in both cases is that the Chinese government objects to it. I regard that as the key point, and it's a slightly different perspective than you heard from Tiffany, and I think her presentation was rich and had a lot of interesting material in it. But I would say that the focus on party autonomy and all those sorts of policies that underlie the world of arbitration, once you take the step and you get a summons from the California court, that is going to hail someone into court and subject them to a default judgment, which is what happened in the Rockefeller case, then you're no longer in the world of arbitration. Then you're in the world of courts and all of the kind of sovereignty concerns that are embodied in Article 10 and its carefully crafted provisions come into play. So with that, I will say thank you very much. I will look forward to questions at the end.
Thank you, Ted. And now we'll move on to Lemuel.
Let me just share screen.
I think Lemuel's transmission has locked up on us. Lemuel, can you hear us? I think let's give him a second to get back in. If he doesn't, Robin will turn to you. Louise Ellen, I think maybe we should go with Robin's presentation and then see if we can get Lemuel if he gets back in.
That sounds like a good plan. Robin, if you wouldn't mind going now.
Sure. And in some ways, I have a lot of follow on from what Ted said, so that I think that works well. So what I wanted to talk about today is kind of more thought experiment than actual exposition, although I hope to sort of talk a little bit about class actions generally for people who might not be fully up on where we are on that in the US. So I too, like many others on the panel, have been thinking about these issues, particularly in relation to the Rockefeller case. I was one of the people who was hoping to sort of advance that issue a little bit further than it got to the Supreme Court. Sadly, we were not successful, but hopefully we'll be able to have the Supreme Court take notice of some of these issues soon, as well as some of the other ones. But I wanted to use the fact and existence of class actions and class action practice in the United States as a way of sort of testing some of the thoughts and intuitions that people have about the Hague Service Convention that I think often are existing in the background. And we kind of wonder about things that really are going on in class action practice and if they should be thought of differently. So I wanted to spend the first sort of half of my presentation talking about the modern state of class actions and the state of notice in class actions. So class actions are a form of aggregate litigation that, maybe 10 or 20 years ago, we would say were almost uniquely American. In the last 10 to 20 years, class action availability has slowly been taking hold around the globe. And of course, that development is a whole other panel that I'm sure people would be eager to discuss and have discussed in other contexts. But let's talk about what the class action means in the United States and how that compares to a few other things, because that's going to play into questions of notice. So class actions are a form of aggregated litigation in which a named representative, or sometimes several named representatives, bring a lawsuit in a representative capacity against defendants. There can also be defendant class actions. Those are pretty rare. And the idea behind aggregate litigation is that when it is, especially a plaintiff class action, that the legal system has allowed plaintiffs or claimants to aggregate their resources. So particularly in situations in which it would not make sense for a single person or claimant to sue because the cost of bringing the lawsuit would exceed any sort of recovery, that by aggregating these claims together, that it enables that sort of resolution and to hold defendants to account for any alleged violations. Now, there are plenty of class actions that aren't necessarily negative expected value suits, but in those cases, it's still considered to be in the interest of efficiency to group claimants together so that you can have an aggregate resolution, and particularly in cases where there's going to be sort of a big payout, a big judgment, a big settlement. One of the ideas is to try to get as many claimants together in one particular proceeding so that there can be some sort of negotiated solution in which you ensure that all of the claimants and possible future claimants are taken care of, and that also you give some assurance of peace or finality to the defendants because there's a single binding judgment that will take care of as many parties as possible. Well, that's where we start interfacing with issues of notice and jurisdiction. So personal jurisdiction, notice, and choice of law have been some of the biggest barriers to having class actions proceed with really, really wide groups of people. So again, that's sort of a whole other topic for presentation. But courts have been very shy about letting big groups of litigants go forward because the idea is that there's not enough commonality between the claimants when in fact the cases would be resolved under different laws, or that the court does not have jurisdiction over all of the claims, or that it is difficult for notice. So let's sort of wrap that part up by talking about how class actions here in the US compare to aggregate practice around the world. So as I mentioned before, class actions were sort of virtually unknown or undone outside of the US and somewhat Canada for a really long time. In the past several decades, there has been sort of an increasing class action or aggregate litigation practice in other countries outside of the US. But even when we see these developments, they don't look exactly like class actions look here. And one of the big differences that I want to highlight is that in other countries that have started to allow limited forms of aggregate litigation, they tend to be what we would call opt-in class actions as opposed to opt-out class actions. So in the US, generally, we have what's called an opt-out class action. So in the federal courts, you find that in Rule 23b3. And the idea is that when the court certifies a class, everyone who meets that class definition is part of the class unless they affirmatively opt out before the court. Now in the US, we actually have some forms of class action that you can't opt out from, but we're not going to worry about those here. We're going to talk about regular sort of generic consumer class actions, which are 23b3. Those you can opt out from. Now, in order to make sure that the class can be certified as an opt-out class, what do you need? You need to make sure that everyone who is eligible to opt out of the class action knows that the class action is going on and has the opportunity to appear and actually opt out of the action. Now, there's a second form of notice that takes place later in the class action in which class members have the ability to object to a settlement if there is a proposed settlement. So that's another form of notice too. Now, in other countries that have started to experiment with class actions, those class actions tend to look more like the idea of opting in, which is that you sort of find everyone to the extent that you can. And instead of presuming that they're part of the class, unless they opt out, they have to actually opt into the lawsuit. And that's because the unpopularity of class actions overseas stemmed from a real sort of hesitation to binding people to a final binding judgment without sort of the full participation and adjudication of claims. So again, that's sort of a real different way of looking at things. So what does this mean in terms of notice? One of the things that I have been really interested in the last couple of years is looking at notice in the US and how it is maybe not as advanced or technologically sophisticated as we might expect it to be, where there have been a lot of other technological advances in law. And it turns out that one of the areas in which notice has moved forward a little bit more than other areas in terms of notice is class action notice. So what, I think we have an incoming child. Here, come here.
Maybe let's go ahead with you because we are running short on time. So let's go ahead here.
Yeah. So sorry about the connection problem. I don't know what happened. But good morning, everyone. So my presentation today is actually part of my broader PhD work, which examined how certain Asian courts approach choice of form clauses in international commercial contracts. My study involved 4 jurisdictions, which share the common law heritage, at least in terms of procedure, that would be Singapore, Hong Kong, Malaysia, and the Philippines. Today, I wish to discuss with you the role of choice of form clauses at the service of process stage. Because of time constraints, I can only focus on exclusive clauses. Nonetheless, I can say that the approaches used in cases involving exclusive clauses are reflected of the general approach of Asian courts covered by my study. That is, it's generally consistent with common law, yet having some unique and different features. First, I would like to give you an overview of the general approaches of the courts covered by my study. Let me share my screen again. Okay. In personam jurisdiction is the aspect of jurisdiction which is relevant to the choice of forum clause in common law jurisdictions. This is true for all four, where the procedural rules are all derived or developed from the common law. Hence, in all four, jurisdiction over the defendant is only acquired after proper service of writ or originating summons. Within the jurisdiction, the service is a matter of right. However, when one would like to serve outside of jurisdiction, leave of court is required in all four. This means that service of process is discretionary and the plaintiff has the burden of establishing the grounds for service. The grounds for extraterritorial service is provided the procedural rules of Singapore, Hong Kong, and Malaysia are similar. In contrast, in the Philippines, the grounds are more limited. That would be only in cases which are classified as in rem and quasi in rem. How about choice of forum clauses in favor of the domestic courts? Are they a ground to serve outside of jurisdiction? In Singapore, Hong Kong, and Malaysia, the respective procedural rules explicitly state that an agreement to submit to the local court is a basis for granting extraterritorial service. The effect of exclusive and non-exclusive clauses, however, may be different. In recent years, however, there is a movement towards giving both exclusive and non-exclusive clauses the same effect, at least with respect to Singapore and Hong Kong. In the Philippines, on the other hand, their procedural rules are silent as regards the effect of choice of forum clauses at the service of process stage. This absence has resulted in the lack of any role choice of forum clauses play in allowing or disallowing service of summons outside the Philippines. How about choice of forum clauses in favor of foreign courts? The procedural rules in all four are silent. However, the decisions in Singapore, Hong Kong, and Malaysia follow the eleftheria, where the English High Court said that when there is an agreement to refer disputes to a foreign court and the defendant apply for a stay of proceedings, the discretion should be exercised in favor of a stay unless there is strong cause. The strong cause test, first developed in the context of a stay of proceedings, is also applied at the service of process stage. Hence, unless there is strong cause, leave to serve out of jurisdiction is denied when the exclusive choice of forum clause stipulates for a foreign forum. So what is strong cause? The eleftheria, I mentioned several factors to consider, like location of evidence, applicable law, genuine desire for trial, and prejudicial factors. One must note that the eleftheria did not mention factors like fraud, undue influence, or overweening bargaining power, which were factors recognized by the United States Supreme Court in the Bremen, which is the landmark case in the US on choice of forum clauses. The courts in Singapore, Hong Kong, would look into the factors mentioned in the eleftheria in determining strong cause, even at the service of process stage. There are no such cases in Malaysia, yet following the approach in the eleftheria, one can argue that in Malaysia, extraterritorial service should also be denied when there is a foreign choice of forum clause, unless there is a strong cause. Take note, however, that there are Malaysian cases at the stay of proceeding stage where factors constituting strong cause appear to be treated in the same way as the factors in the forum non-convenience test. That is, the court will engage in balancing the factors in order to determine the forum which is more convenient. So what are the factors identified by the courts in Singapore, Hong Kong, and Malaysia as amounting to strong cause? So I would like you to refer to the table in the screen. Note that while convenience factors were also considered sufficient to establish strong cause during the early years following the Eleftheria, their significance has diminished over the years in Singapore and Hong Kong. In contrast, in Malaysia, strong cause can still be established by convenience factors. The establishment of the Singapore International Commercial Court brought complexities to the Singaporean law on choice of forum clauses. The SICC was established in 2014 and became operational the year after. The establishment is pursuant to Singapore's desire to strengthen its status as a regional hub for dispute resolution, and is sought to complement the earlier established Singapore International Arbitration Center. So what happens to cases before the SICC where there is a choice of forum clause? Cases under the SICC can be commenced through the same procedures in the rules of court. However, Order 110 forgoes the need for leave when there is a written clause stipulating the SICC. So notably, this radical procedural change applies to both exclusive and non-exclusive clauses. So by dispensing with the leave requirement, the SICC in effect makes the service of process in and out of Singapore as a matter of right. Significantly, the defendant in both instances has the burden of convincing the court not to exercise its jurisdiction. However, when a third party is joined, service out of Singapore still needs to comply with the leave requirement following the standards under common law. Another complication arose when Singapore became a party to the Choice of Court Convention and passed its implementing legislation, the Choice of Court Agreements Act. One must note that the Choice of Court Convention and the CCAA do not deal with matters involving service of process to commence proceedings, actions, or claims involving choice of forum clauses. This is left to Singapore law to determine. Nonetheless, because the convention affects exclusive choice of forum clauses in matters it covers, the test applicable to service out of Singapore is modified. The grant of leave appears to be no longer discretionary when matters falls within the scope of the convention, and a Singaporean court is chosen because extraterritorial service becomes a necessary step for the chosen Singapore court to exercise jurisdiction. In the same way, if the Singapore court is not the chosen court, it has no discretion to grant leave to serve process extraterritorially. There are exceptions to the foregoing rules, but these are limited only to instances where the agreement is null and void, where the giving effect to the agreement would lead to manifest injustice or would be manifestly contrary to Singapore's public policy, where the agreement cannot reasonably be performed because of exceptional reasons beyond the control of the parties, or where the chosen court has decided not to hear the case. CCAA cases under the SICC do not encounter these issues because leave is not required when there are exclusive choice of forum clauses. Before I discuss my final notes and conclusions, I would like to say more about the Philippines. In the Philippines, the choice of forum clause becomes relevant once the court assumes jurisdiction over the case, at the stage where the defendant seeks the dismissal of the action through a motion to dismiss. Because the courts have treated choice of forum clauses as venue stipulations, and action may be dismissed because it was improperly laid. Furthermore, even when there is no direct ground for dismissal, which is available under the rules of court, the court may still refuse to exercise its jurisdiction because of forum non-convenience. Philippine courts have recognized that choice of forum clauses are among the factors to be considered in the forum non-convenience test. So my final notes and conclusions. The strong cause test used at the service of process stage is the same as the one used at the stay of proceeding stage. Hence, rules developed at the stay of proceedings should be applicable to the service of process stage. Yet take note of the differences in the burden of proof. Burden of proof at the stay of proceeding stage is with the defendant, at the service of process stage, the burden lies with the plaintiff. Likewise, take note that there may be differences in the specific grounds available because of the differences in the procedural rules. Singapore has become a very complex jurisdiction as regards the effect of choice of forum clauses. Take note that there are different types of cases involving choice of forum clauses which are heard before Singapore courts. And for each type of case, a different set of procedural rules may apply. So therefore, Singapore presents a window where one can observe the complicated interactions, for instance, of the choice of court convention with the domestic legal system's own complexities. Hence, the vision of promoting harmony and uniformity of rules may not be easy to achieve given this Gordian interaction. Hong Kong and Malaysia continue to follow the English common law approach, although Malaysian courts may still engage in a balancing of factors type of approach similar to forum non-convenience, even when the choice of forum clause involved is exclusive. Nonetheless, all four jurisdictions give effect to the choice of forum clause, although it is only in Singapore, Hong Kong, and Malaysia where choice of forum clause are relevant at the service of process stage. So even in jurisdictions sharing the common law heritage, the approach may be similar but not uniform or the same. Hence, it is important to look at the relevant procedural rules. So I end my presentations. If you have, I would be happy to answer any questions later, or you may reach me at lemlopez@gmail.com. Thank you.
Thank you, Lemuel. We're going to go back now to Robin for a 60-second conclusion to her presentation.
All right, so I'm happy to give you all the punchline to where I was leading up to, which is that in US class action practice, notice does not necessarily look like the traditional service of process that we were used to, even in old class action notice where you would get maybe a postcard or a piece of paper. So courts have authorized email with some regularity, but also text message, other forms of direct messaging on social media. And even more interestingly, there are sort of new forms of notice by publication. So not just publishing notices about class actions in relevant newspapers, but also things like targeted advertising, in which they will use algorithms to sort of make sure that an ad with a class action notice pops up in the feed of someone who the court or the notice planners believes is a potential class member. So I'll just sort of leave you all with the tantalizing question: what does this mean for the Hague Service Convention? So in general, there hasn't been a lot of attention paid to the transmittal of notice in class action notice, even though it is, in fact, notice that is transmitted cross-border. And so we can ask the email question. But I think it really pushes us to ask all of the questions that Ted was asking in his presentation about the difference between notice and power and sovereignty, about who is serving and what it means to transmit a document when, say, it is just an algorithm pushing a notice into someone's feed who may or may not be outside of the territory of the United States. So I will leave it there and try to answer anything else in Q&A.
Thank you, Robin. I'm going to exercise some moderator's prerogative here. We have one question in the Q&A, and I want to address that, but I want to make some distinctions. I think what the panelists have done here is point out some really, in an excellent way, distinctions that are important. So I wanted to try to summarize those distinctions, and then if we have time, get comments on that. The first distinction, and this takes us to the question that is in Q&A, and that is about mediation as well as arbitration. I think, as Tiffany pointed out, arbitration involves party autonomy in a different way than litigation does, because it's all based upon party autonomy. And I think most would agree that therefore the Hague Service Convention really doesn't have application to the arbitration proceedings alone. But in SinoType, after arbitration, we went to court, and the convention does have application once you go to court to confirm or try to recognize the arbitral award. That takes us to Ted's presentation. And there the distinction is not between ADR and litigation, but rather between party autonomy and sovereign rights. And as Ted pointed out, I think sovereign rights are important. They are recognized in the convention. And as the US Supreme Court said in the Schunk case, once you're in the convention, it is exclusive and you must use it. And we in the United States do have to acknowledge that in most of the world, notice is a sovereign service, is a sovereign function, even if we can do it with anyone over a certain age in the United States. So that distinction is important. But this, I think, brings us back to what you can do privately and what you can do through sovereign matters. And it takes us to another one of Ted's issues, and that was waiver. And the Supreme Court of California ultimately said that under California law, what we had was an effective waiver. And this is the debate that I think is going to continue in the United States. But the real lesson here takes us to Lemuel's presentation, I think, and which is something that's more difficult in the class action under Robin's presentation, and that is it's really not a litigation matter. It's not an arbitration matter. It's a contract drafting matter. And the real question is, what can you do in contract drafting? And can you waive service? Can you waive on behalf of a foreign sovereign, as Ted would say? I think, and I think the answer to that is probably no. Now, California says you can waive under California law, but I think the very simple answer is you don't have to do that, because back to Article 1, you only need, the convention is exclusive only when there is occasion to transmit documents for service abroad. And so if you draft your clause to say that you consent to receive service of process locally through an agent for service of process, then you no longer have occasion to transmit documents for service abroad. You're no longer within the convention, and the convention is not exclusive because you don't even have to address it. So better off to draft a local service clause with consent to local service than to try to draft waiver, because it's going to lead you to more litigation. We have about 2 minutes to have panelists respond and see if I got the distinctions right on that one.
Ron, let me say, I agree with you 100%. And I guess this is really a question for Tiffany. Ron has pointed out, I think, one way in which your proposal, might be, in a sense, unnecessary because you could draft around the problem that you're raising. But I would also be curious to know why, in the world where we have the New York Convention, where you can just take an award abroad, and assuming that we agree that the award itself is not a judicial or extrajudicial document that is subject to the convention when it gets sent, what is the motivation really for the view? I mean, in other words, why is it important to fix this problem if Rockefeller, to take the case that we've been talking about, could have just taken the award to China and sought confirmation in a Chinese court?
Thank you for the question. And I do agree with most, if not all, of the points that were raised by both you, Ted, and Professor Brand. But when it comes to arbitration-related proceedings, confirmation, enforcement, recognition, that's really more of the contention, right? And because it takes us back to the judicial forum. And the reason why I've been raising this matter, or at least highlighting this, is that I agree with you that there is a way around it, the way of contracting around it. And that is one of the questions that I had pointed out at the start of my presentation, right? You can always draft the contract that will just put you out of the service convention and just have it served within and notified within the territory where the parties are located or where the assets are located. I agree with that 100%. The reason why I'm raising this matter is because I have found some gaps in the law and some conflicting national decisions from different contracting state parties, which, to my mind, lessens the finality and the binding nature of an enforceable award, which goes against the very nature of the New York Convention. And that is why I'm arguing for this type of approach when it comes to arbitration and arbitration-related proceedings, because although ordinarily it will bring us back to the scope of the judicial forum, its very nature is really very different, although it is still part of litigation. And that is really why I'm arguing this. And there are a bunch of different cases I can cite, and which unfortunately I didn't have the time to discuss. But time permitting, maybe in another forum someday, we can discuss that. And even separately between the two of us.
We are at the end of our time, and I know that the system, as I understand it, is designed to shut us off at 12:05, and it's now 12:04. So with that, I'm going to, as moderator, say thank you so much to our panelists for an incredibly rich discussion that brought in a whole set of factors and elements. And thank you to those who joined us and listened. I look forward to seeing you all in person next year at ILW 2022, so that we can then simply walk out in the hallway and continue this conversation as we should be able to do. So until then, take care, and thank you all for joining us.